All right, thank you folks very much. All right, second case on the docket this morning, case 23-91, Rodney Turnovsky versus State of Florida. It's a little dark in here, isn't it? Maybe because it's so overcast. Not getting the sunlight. All right, again, it's 20 minutes per side. Mr. Elferman, you can reserve as much of that as you would like for rebuttal. I'll set it at 5 minutes unless you would like something different.
Good morning. May it please the court. Michael Elferman on behalf of the appellant Rodney Turnovsky. I'd like to reserve 5 minutes of my time for rebuttal.
Sure.
I'm hoping to focus my time this morning on the first two issues in the briefs. I'll begin with the first issue, and that is whether the trial court erred by denying Mr. Turnovsky's motion for a new trial that was based on a Brady claim and a newly discovered evidence claim in light of Michelle Turnovsky's email that was sent to defense counsel after the trial. Now, my client was charged with possession of child pornography, and the theory of defense in this case was that my client's mother is the one that planted those items onto my client's devices. It was known throughout the trial that Ms. Turnovsky potentially would be a rebuttal witness for the state, but ultimately, when we got to the end of the trial, the state announced that they would not be calling Ms. Turnovsky as a witness. And then after the trial, defense counsel received this email from Ms. Turnovsky. And in the email, she admitted to a number of bad things. She said she was an alcoholic. She said that, yes, she had had her son when she was in a juvenile detention facility. She had previously held a gun to his head. And yes, they had a very acrimonious relationship. And
Wasn't her statement at the end of that then referred to all those bad acts when she said, okay, I did what they said I did. I did all the things they said. Who's they, if not the state?
And let me read it. At the very end, she says, she, referring to the prosecutor, did not call me to the stand because she knew I would cause reasonable doubt due to the fact that I did do all the things they said I did. Yes, I acknowledge, Your Honor, one interpretation of that is that all the things that are referenced is what she's admitting that she did. But I submit that it's also a reasonable interpretation, especially, I don't think it was any secret to her or anyone else who was involved in this case, that the theory of defense is that she's the one that planted these items. That it could also be read to interpret, or also be read to mean that she's admitting that she did do what the defense is alleging she did. She planted these items. So the substance of the Brady argument is defense didn't know that she was going to make any admission. It's not for the state to decide whether or not that admission means one interpretation or the other interpretation, but the state, upon knowing that, and I would point out at the motion for new trial hearing, the state didn't deny anything from this letter. They didn't say, no, that didn't occur. They didn't say, no, we didn't make that statement to her as to why we're not going to call her. So that if it's established, and I believe it is in this record, that that's exactly why the prosecutor decided not to call Ms. Turnovsky as a rebuttal witness, due to the fact that she did do all the things that they said that I did. That's something that the prosecutor under Brady had an obligation to inform defense counsel at the moment that was said while the trial was still ongoing.
Even assuming all of that is correct, did not defense trial counsel, in response to the court's questions, concede on the record that the email was not itself exculpatory, but merely would provide a predicate for, finding further evidence, which is not disclosed in this record, right? I mean, and how is that not a invited error, or at the very least a waived error?
That's what the state's argued, obviously. I submit that that's not exactly what defense counsel said during the motion for new trial hearing. Defense counsel was asked very specifically by the judge, you acknowledge that this isn't an explicit admission that I planted items. And defense counsel conceded that this doesn't say that. But I still think defense counsel's argument throughout the motion for new trial was this amounts to exculpatory information. There's no other way that I can, the only interpretation I can give to defense counsel's argument, when he's saying that it's exculpatory information, he must mean exculpatory in the sense that it's an admission that she planted the items. Because, again, as the state's argued, I don't disagree with that. The judge had ruled pre-trial, and even though some of it nevertheless came in, that it's not necessarily exculpatory about all these bad things that she did. The judge precluded some of that from coming in, but nevertheless, through the two defense witnesses, a lot of that never came out. The jury got to hear about that.
So can you walk me through the defense's theory on just a factual basis, how it would be physically possible for the mother to have planted this evidence, given the very secret location of the key being locked in the safe? Can you just walk us through what the inference would be that you would ask the jury to make, even if the mother were to have testified and said, yes, I did this? How can the jury, what would the jury have had to go on to credit such testimony for a mother who's already said, that she prefers that her son not be punished, and has a motive, to provide that sort of testimony? I mean, what would be the inference factually that the jury would make about how she got access?
Well, let me begin by saying, if it would have been an explicit admission, which your question almost presupposes, I submit that there's no question that this court would have to reverse. I don't think you'd be able to say it's harmless, and because of the other evidence, we find it would be impossible for her to have actually done this. I submit that would at least rise to the level that you would find that that's for a jury to decide if she would have made an explicit admission. So let's say she had made an explicit admission. The state responds and says, look, and they quote extensively from the prosecutor's closing argument, there's items that were accessed on this date, on that date, and it all seems to link back to only the defendant. Yes, we do have this safe, and there's a smaller, apparently, lockbox within that safe, but there's no dispute in the record that the key was right there, and anyone could have accessed it. So the defense's theory was that the mother, obviously, I don't know if there's any dispute, had a lot of animosity towards my client, that this goes back all the way to the day that my client was born and subsequent actions. There was disputes involving my client's grandmother, Ms. Ternovsky's mother, and the money, and that my client was in charge of her finances, and the mother wanted more control of those finances or wanted those finances for herself. So there's no doubt that there's a potential motive for this to have occurred. Obviously, I know it's not admissible. The judge found defense counsel below conceded that it would only be impeachment, but we do have the Warswick affidavit that would at least corroborate that she's made an admission that she in fact planted the evidence. And again, the evidence was that she had access to this house at all times, so that she lived there for a period of time. She would come over, she had a key. There were times that my client was not at the house, so it was certainly possible that if she wanted to plant this evidence, she could have planted the evidence. Now, the state tries to make a big deal that, they would have had to know the exact date that the law enforcement was going to respond, and she'd have to know the exact date to put a thumb drive inside his work bag. I understand all that, but ultimately that's an issue for the jury to decide. But it's a defense, and this clearly was the theory. It's not an after-the-fact theory that defense counsel was bringing up for the first time in the motion for new trial. This was the theory that was presented in opening statement and argued throughout the entire trial, that she's the one that's planted this evidence. So again, I submit that the state had the obligation, once they knew of this, to disclose it to defense counsel. Defense counsel at that point could have actually called Ms. Ternovsky and seen what she would have said. But as we sit here today, we don't know what Ms. Ternovsky would say. We have, again, some corroboration through the Warswick affidavit where she made the admission to him, but we do not know what she would say because the defense was denied the opportunity to call her, and I submit, defense counsel argued this, had he known that she would have said what she said in this email at the time of trial, they would have put her on the stand, presented that to the jury, and I submit that would meet the Brady standard, that would meet the newly discovered evidence standard. There's a reasonable likelihood that if that admission had come out to this jury, that my client would not have been convicted. Let me move, unless there's any other questions regarding the first issue, let me move on to the second issue. The second issue concerns the state's presenting to the jury that the 2 thumb drives that are at issue, there's 10 images on one thumb drive, 10 images on the other thumb drive. One was found in my client's work bag, the other one was found in this locked safe. That there was also a video on each of those thumb drives, the same video, of my client recording himself having sex with his girlfriend. And this issue was brought up pre-trial, and the defense said, hey, we understand that they're wanting to present evidence of this other video, and we don't object to them presenting the video itself from, or any evidence or testimony that would establish that there was a video of Mr. Chernovsky.
So Mr. Ufferman, can you walk me through, how, what your thought would be about a potential inference the jury might draw from the fact of, this sex video? One is more likely to keep from the control and access of others a depiction of intimate moments of oneself, right? Highly more likely to do that. Also, that the placement of that sort of intimate recording is much more likely to have been done by the person it depicts rather than someone else. Therefore, because this is a recording of an intimate nature, that the fact that it's that subject matter makes it more likely that the defendant would have retained very close control of the drive on which that video was found and would not have been accessible to others. Are you disputing any of those inferences?
I am.
Okay,
and
so please walk us through why those inferences are wrong.
Thank you, Your Honor. I appreciate you asking. So there's no dispute that the video was also on the computer in the house. And my client's theory is the mother could have had access to that computer. It wasn't in some secret location. It was right there in the computer that anyone could have accessed. This idea that, the whole point of this is, look, we're trying to show that this thumb drive belongs to the defendant, and of course I acknowledge, defense counsel below acknowledged, that if you have a video of the defendant on the same thumb drive that has the illegal images, it certainly makes it more likely, supports the state's theory of prosecution, that he's the one that possesses that thumb drive. So does it make it that much more likely that the video of the defendant is of him having sex with his girlfriend, or recording himself having sex with his girlfriend, as opposed to being a video of the defendant? Let's say he's on the beach and he's narrating and he says, good morning, it's December 1st and it's a beautiful day here in Daytona Beach, and here I am and there's waves in the background. If that had been the case, if that had been the video, the state would, I would submit, have just as strong an argument that we know these are his images. He's got a video of himself on the same thumb drive with the images. Clearly it's not anyone else's.
One is more likely to closely safeguard a video recording of one having sex than one being on the beach. Fair? Would that be a fair inference? Such that, the access that individuals other than the defendant would have had to a video recording of him on the beach is presumably much broader than the access that other individuals would have on the subject recording.
But his theory is that those aren't my thumb drives. I didn't put the video or the images on the thumb drives. So that idea doesn't relate to or refute anything the defense is trying to present. His theory is it's not.
Is that the limitation for the determination of admissibility of evidence?
Well, no, but it's certainly.
We start with the presumption relevant evidence is admissible, right? That's the evidence code. We all agree with that. Relevant evidence, unless excluded, is admissible.
Is it, well, I would respond by saying it's not relevant that he has a video of him having sex with his girlfriend.
So let me, and I think Judge Pratt's, perhaps, I don't want to speak for him, looking at similar issues that I may be looking at. Fundamentally, relevant evidence, unless excluded, is admissible. Relevance is defined as that which tends to prove or disprove a material fact. One being in possession, custody, or control of a thumb drive or thumb drives or hard drive computer with such intimate videos and depictions may well be, one could argue, highly relevant to the state's ability to prove possession, custody, or control by the one who has been depicted in such an intimate moment. The fact that it may not be relevant to the defendant's viewpoint or may not be inconsistent or disprove the defendant's viewpoint, that's not the determination we're called upon to make, are we?
But 403 does require balancing. So the question becomes, is the prejudicial impact, does it outweigh any probative value?
All right, so let's talk about that then. If ultimately the thumb drive contains horrific child pornography videos, Is it your client's contention that the video depiction of consensual conduct between two consenting adults is unfairly prejudicial and relevant to the charge? That's his argument.
Yes. Can I further explain that?
Absolutely.
Because his argument is, I don't possess those images. They're not mine. But now the jury's being told that he likes to record himself having sex with his girlfriend. There could be, as I've argued in both my briefs, someone on that jury that finds that in and of itself repulsive. And that, if he's the type of guy that's going to record himself having sex with his girlfriend, that's creepy. And boy, that must mean he's the type of person that would actually possess child porn. Whereas, if the video was simply, this is a video of Mr. Ternovsky, and it's on that same thumb drive with him possessing child pornography, the state's still able to make their argument, but the prejudice to my client when the jury, even just one of them, is thinking, oh, he's a creepy guy. He records himself having sex with his girlfriend. There was testimony about, this is a picture of his hand positioning the camera as he's getting ready to have sex. So yes, the prejudicial impact of that outweighs the probative value, especially in light of the concession that the defense is willing...
Go ahead, I'm sorry.
The defense is willing to concede that you can definitely tell this jury that there's a video of him on those thumb drives, but to go one step further and describe it as him recording himself having sex with his girlfriend, that's when it becomes too prejudicial.
Right. So then your contention obviously is the trial court then would have abused his discretion by admitting the video of that encounter between two adults. Does perhaps the defense asserted by the appellant heighten the probative value for determination of 403? Does the defense assert and heighten the probative value of the thumb drive and of the other videos on the thumb drives?
Well, two answers to that. Number one, at that point, my client hadn't testified, and the court made this ruling pre-trial. But beyond that, I don't think this defense in any way makes the state's argument stronger or makes it more relevant. Again, his theory is, I didn't know the thumb drives were either in the safe or in my work bag. That video of me recording myself having sex with my girlfriend is on the computer. My mother could have accessed that, but I didn't put that video on either of these thumb drives. So the fact that it's an intimate video as opposed to just a video of him doing whatever, as defense counsel argued, getting ice cream, I don't understand why that makes it more relevant. The state is still able to make its argument. Again, if the argument from defense counsel was only like you got to exclude it altogether, I think it's not relevant. I've conceded. I think defense counsel below conceded. Yes, it is relevant. The state has a right to tell the jury that there was another video of him or a video of him on that thumb drive with those images. That's clearly relevant to their possession argument. But to go one step further and say it's a video of him recording himself having sex, the possibility that, again, his theory is I didn't do this, someone else planted this, but if one of the jurors is put off by the fact that he recorded himself having sex with his girlfriend and that made it so he didn't get a fair trial or they didn't properly consider this, or that juror said, I think it's more likely that means he must be possessing this child pornography, then the ruling was wrong. It was an abuse of discretion and my client didn't get a fair trial. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you.
All right, thank you, counsel. Okay.
Good morning. May it please the court, Virginia Harris on behalf of the state of Florida. Beginning with issue 1, and you've brought up some of my arguments for me, our position is that defense counsel came off this, that when he was pointedly asked by the judge basically said, look, Michelle Ternovsky, the mother, never said that she planted this evidence, and the state never disputed that she was a bad mom in these prior bad acts. And he said, I agree. She never came out and said that. That would have fit under Rule 3.600 and 3850. He then goes in to say, but had he known, it could have led to exculpatory standard. Right there. So exculpatory evidence. So he's admitting that it's not exculpatory evidence. And then when you look at the context of her letter, it's very obvious that she's talking about the prior bad acts. Or not letter, email. It starts out by saying that the prosecutor came out to talk to her during a recess, and that she's actually told her, you're going to testify. I think she said at 1:15. Then she goes through all of these things that have nothing to do with the case, about alcohol use, drugs, did she have arguments with her son, and she agrees to most of this stuff. There is nothing about planning the evidence, nothing about access to the house, nothing like that. She doesn't even agree to the, quote, financial motive. Then she says the prosecutor said, I've never heard such bad things said about another person, and starts to ask about what the defendant's great uncle and the defendant said. Then the prosecutor doesn't call her, so her statements are indicating, I admitted, because I admitted to this might have, led to reasonable doubt, talking about these acts. Appellant overlooks that no one actually testified that the mother planted this evidence. They presented testimony that she had a motive in access, but no one had any personal knowledge that she had allegedly did this, so there was no evidence that she did this. So she is clearly not talking about this. Defense counsel did not get a sworn statement from her. In fact, the record indicates that she was there under a state subpoena. And so there's no proof that she even wrote this email. And so I think that pretty much tells you all you need to know right there. And he did have a sworn statement from Warswick, which appellant has waived on appeal. So it's not like he didn't know that he needed to do that. And then the diligence prong, which would go more to the new trial standard. There's equal access to this. New evidence is not, I didn't properly investigate my case, so it's new to me. He knew what his defense was. This was an opening. He could have spoken to the mom about this. And he didn't. So he didn't use diligence, and it wouldn't have changed the outcome of the trial. The evidence was overwhelming. The one thumb drive was actually found in the defendant's work bag on his person when they encountered him in the driveway, and then the other thumb drive was in his safe. He provided the passcode and told the police where the key was. The only other person that lived there was his girlfriend. She denied it. And when he was interviewed by police, they asked him in a number of different ways about who had access to this. He never mentions his mom. He says that everything's password protected and secure. And so this is clearly something that he came up with later. If there aren't any more questions about this, I'll move on to issue 2, which is the intermingled video of his girlfriend. This is clearly relevant, not just because it shows him as the person in possession, but he actually exercised control over it there's evidence that it was accessed later, like a year later, and that the child pornography and the images were looked at on the same day. So if his mom is the one who really did all of this, why would she want to look at these videos? It's as though at the time he felt that he wanted to look at the sexually related material. He wanted to look at both of them at the same time, which goes to possession and also rebuts the defense theory. And then once again, even if error occurred, it would be harmless. I mentioned the overwhelming.
Before we get to harmless, so we covered relevance. Could you address a little bit, the weight, the probative value of the evidence, and just respond to your friend on the other side about the video on the beach example, right? Like, why the state, viewed this recording, the jury needed to see the whole thing instead of just mentioning that it was depicting.
They didn't see the video. They just showed a headshot and presented testimony. But it shows that it's not just his thumb drive, but a thumb drive where he keeps sexually related material, and then also accessed it later. So they were accessed at the same time. Appellant mentions, but we were going to stipulate or concede he was on there. The defense is not allowed to force the state in a stipulation to do away with its evidence. There's a case called Old Chief, a United States Supreme Court case that's very good at explaining about, aside from status offenses like possession of a firearm by a convicted felon, that the defense is not allowed to force the state into a stipulation, that it does not have the same kind of effect as the jury hearing all of this evidence. So the defense is not allowed to just say, hey, we don't want you to hear this, so we'll stipulate that he's on there. And then the Scott case, which I cited out of the 4th District, it's similar. It had child pornography on a thumb drive, and it allowed evidence of other crimes, of the defendant actually, he was videoing young girls going into his bathroom without their knowledge, and I guess his girlfriend or wife identified his torso, and they said that that was admissible to show possession. And I realized that Mr. Ufferman has argued that, well, in the briefs, it would show it was inextricably intertwined, but that's not what the 4th District said. The holding from that case is what the 4th District said. You don't go back and look at what the parties wrote in the briefs as to that, and they don't say anything about it being admissible because it was inextricably intertwined. So that court allowed much more damaging evidence and said it was relevant, and that the probative value was not substantially outweighed by the danger of unfair prejudice. So in this case, this is legal material. I mean, 2 consenting adults, his girlfriend, there may be somebody out there that doesn't like that, but it doesn't even come close to outweighing the probative value in this case. If there aren't any further questions, we ask that you affirm.
All right, thank you, counsel.
May it please the court. Let me just quickly address a couple points relating to the second claim. The idea that the video was accessed around the same time, again, that would be no different whether the video is of my client at the beach or having ice cream, or whether or not the video is of my client recording himself having sex with his girlfriend. The state would have been able to make that same argument. Oh, by the way, someone accessed these images on the thumb drive on this date, and this other video of the defendant was accessed on that same date. So they still would have been able to make that point without telling the jury that that video is of my client recording himself having sex with his girlfriend. And again, I do think the Scott case is distinguishable. I don't think we can look at this case in a vacuum when we know what the underlying facts are. The video in question in Scott was the defendant engaging in illegal conduct. And again, it was established in that case that was inextricably intertwined. The defendant was actually charged with that underlying conduct of the video voyeurism. In this case, my client taking a video of himself having sex with his girlfriend is in no way illegal, but the concern is, at the end of the day, if just one juror thinks that that's inappropriate, that's improper conduct, that prejudice outweighs whatever slight benefit the state might get by telling the jury that, oh, this is of an intimate nature, or it's these sex images and this sex video. The state would have been able to accomplish the same purpose and been able to make the same argument to the jury in closing by saying, look, we believe these are his images because a video of him is on those thumb drives. But it was extremely prejudicial to let the jury know that my client recorded himself having sex with his girlfriend, and therefore I'd ask this court to reverse. Thank you.
All right, thank you, counsel.